Gordon Hall helped me with one part of it. He said to me, I said, look, if I'm suing them for a lot of money and they come at me and they say, look, we'll give you $1 million, what should I do? I said, I could use the $1 million. What do I do? And he gave me a great answer. So this is a great answer from Gordon Hall. He says, I conditionally accept your offer of $1 million, but that does not negate the fact that there's still an outstanding balance between us. So he said that way you could still take the money, but at least
you're leaving it open for the rest. Yeah.
Right, because I've seen what happened in a case was called Rayleigh versus Maine. It was an Alabama case, and the game warden shot some man in the back. So he was found guilty, and I think he's either sitting in state prison or federal prison. So the widow of the man who got shot in the back, the game warden tried to say the man was going for a gun, but he was just going for his driver's license, like the game warden told him to give him. So he shot at the man in the back, and they had video cameras, so the game warden is in jail. But anyway, the widow, I'm not sure exactly how much she asked, but she asked for like $1 million. So then what happened was, you folks got to be really careful when you make a wish for, like, say, $1 million, because that's what they asked me. They said, what do you wish for a settlement? So the judges use those words. Wishes are very powerful. So when she was made an offer of, like, say, $500,000, she accepted. And as soon as she accepted, her $1 million claim to be made whole and complete was deemed to be fraud. Because if you say to be whole and complete, cost me will be $1 million, and then they come back with a counter offer, say $500,000, and you accept it, well, then your $1 million claim was a false claim, and then every part of your claim gets thrown out and dismissed. So I don't know if she ever got any money at all, but I'm warning you folks, when I read that case, I was like, holy cow, because if they gave me a lower offer and I accepted it, my whole entire claim would have been thrown out. And how I try to explain to people is like, say, National Geographic was giving somebody a $1 million prize for discovering the South Pole. Who's ever run for South Pole first, like, say, 100 years ago, gets $1 million. So if Admiral Byrd went down there and he said, well, I discovered the South Pole, I put a flag there, here's a photo, and give me my $1 million. What attorneys try to do to you in court is they try to play the word reasonable. So if he's like, come on, it was cold, it was 30 degrees below zero, come on, are you sure your compass really read zero? You know, come on, maybe you were off by 1 millimeter. Come on, be reasonable to this jury now. Not be reasonable. Tell us the truth. Maybe you might have been off by maybe a micron, maybe a millimeter. And if he says yes, then he didn't hit the South Pole. Mm-hmm. So what you would have to do is like, no, that is my word, and I'm sticking to it unless a man could come forth and claim that my claim is a false claim, that I did not hit the South Pole, then my claim stands as true until somebody comes here before the National Geographic Society and says that I filed a false claim. Then you could sue me to get the $1 million back. But until then, I want every damn dime that you said is the prize to hit the South Pole. I hit it. Anybody else wants to claim I didn't? Bring your claim forward. But until then, I demand the money. So attorneys try to play this reasonable nonsense with you. So whenever you hear an attorney say reasonable, run like hell, because that's how they get you to say from it breaks your word, because your word is your bond. And if you move one iota off of your belief, and they could move you off your standing, they can knock you off your pedestal, your whole entire claim gets thrown out the window. So just stick to your guns, and when they say something, just say, that's my word, and I'm sticking to it. So like I said, my claim is going in, and like I said, I just printed out some orders, and the orders are really simple. Like I try to tell people, I said, like, the one order is just say, it is the order of court. When you say it is the order of court, court means me, or the jury, and the defendant. We're the court, not the judge or the clerks. It's the order of court. You don't hear the word this court. It's just court. That the state of Alabama's court case stylized as JU 2001-51832 is to be known to the world as void ab initio, and all of its subsequent orders are to have no force of operation. So that's how simple an order has to be. It doesn't have to be elaborate. It doesn't have to be huge. It's a nice, simple order. I'm just basically saying I want the world to look at this case as a false case, and that every subsequent order that came from this case is to be noticed as a void, or known as. You don't want to use the word deemed, because deemed is a legalese word. And every single thing I write, there's not one legalese word in it. So when they try to come at me with legalese, like say, well, you're pro se, I say, no, I'm not pro se. I don't know what that means. Where can I find that in a common parlance? Where can I find that in a common term? I'm not pro se. I'm just a man. And if you try to diminish my standing, if you try to knock me off my pedestal as a man, I can't accept that. I'm just an aggrieved man. An aggrieved just means somebody who's lost his rights, and he wants his rights back.